Hi friends, how are you all? I hope you all are fine. So what we saw previous classes, we have seen that about Article 12. So I would like to remind you what is Article 12. It is nothing just about the definition of the state. What is a state? Okay. So when we talk about the definition of the state, so we will have to focus on 4 points. First is the assembly. Assembly means parliament and state legislature. So when we will talk about the parliament and state legislature, so we will have to understand that it is a state. And second point is our council ministers. Okay, it may be at the center or at the state level. Okay, so when we talk about council of ministers, so it is a state. And the third is local authorities, that is like panchayat, municipalities, what words are like these things. Okay, and other authorities were whenever a constitution, an organization, or any hospital, colleges which will be conducted by the state functionally, financially, or administratively, so that will be considered as a state. Okay, so in the next move we would have in understand that what was judiciary. It is a state or not a state. So first we would have to understand that what is judiciary and what it works. So judiciary basically works to two works. Okay, that is, first is administrative work and second is the lawmaking process. Okay, when judiciary will do administrative work, like just understand that and just assume that someone filed the case against me. Okay, and I go to the court, and judiciary will give me the judgment, so that will be considered as a judiciary is not a state. But when it will make the law and that will be followed by the citizens of India, so that will be considered as a judiciary is a state. Okay, so in the next move we are going to discuss about article 13. Okay, so we are going to discuss about article 13. So article 13 basically it's a very important article with the context of fundamental right, because it protects our fundamental right and rights also. Okay, so see, article 30 basically talks about when any law will be inconsistent with the fundamental right, so that law will be held null and void and fundamental right will prevail. So what is it mean? In the simple word, if I would I would say, so that will be, if government is making any law tomorrow, okay, and that is infringing or that is taking away our fundamental right, so that law will be null and void. It means that will not be in operative mode, it will automatically be inoperative. Okay, see, today the government is making any laws which is infringing our right to liberty, right to freedom to move anywhere. Okay, so if government is making any law and he is saying that you will not have to go here and there, okay, just normally. Okay, so that law will be null and void and it automatically will be deleted. So that's why article 13 is very important when we talk about the fundamental right, because it protects our rights, it protects our fundamental right. So I would say once more. Okay, so so article 13 is nothing but when any law which will be implemented by the government, and that law will be inconsistent in nature with the fundamental right, so that law will be held null and void. Okay, so it is our article 13. And in the next move we are going to discuss about article 13 clause a. What is article 13 clause a? Okay, so article 13 clause a basically talks about when any British law which is inconsistent in nature with the fundamental right, so that will be, or in our constitution. Okay, it means when any law of the British rule, if that is inconsistent in with fundamental right or our constitution, so that will be null and void. Okay, like see, automatically will be null and void. uh, Before the 1950, when before the 1915, when British rule were in the force, so there are lots of laws which were against our liberty, right to liberty, right to freedom, anything whatever we wanna do, so that will automatically will be deleted, and that will be considered as a null and void. As an example we can say that the Indian Penal Code, okay, which was came into force 1816, okay, 1860. So in the Indian Penal Code is good and bad as well. Okay, so if that will be good, so that will be existence, so that will be in operative mode. But when any part of this will be inconsistent in nature, so that will automatically will be null and void. As an example we can say that there are 20 sections in the Indian Penal Code, and 18 sections is consistent with our constitution, but 2 sections are inconsistent in nature. Okay, so that will be automatically null and void, that 2 sections will not prevail over our constitution. So that's why article 13 and article 13 clause a is very important for our constitution, very important for our rights, fundamental rights. Okay, so I would say once more, article 13. What is article 13? So article 13, if government is making any laws which is inconsistent with our fundamental right, so that will be null and void, and that will not be operated. Okay, and article 13 clause a talks about when any laws in of British law, I mean any British law which is inconsistent in nature or inconsistent with our constitution, so that will be deleted, or that will be null and void. Okay, so I hope you all got it. Okay, so thank you for watching this video.